Good morning. We are on the record. The Maryland Public Service Commission will come to order in docket number RM77. This is with respect to small generator facility interconnection regulations. On June 28th, the Commission issued a notice making this the time and place for the Commission to hear from parties with respect to the regulations that staff filed back on June 23rd with its petition for a rulemaking. Since then, we've received 6 sets of comments from interested parties, and we'll hear from others today during the course of the rulemaking session. The commissioners have reviewed the petition as well as the draft regulations and the Phase 4 report that was filed by the engineering division here at the PSC. At this point, I will turn it over to the engineering division led by Chief Engineer John Borkowski to provide us with a presentation with respect to the proposed regulations. Good morning, Chief.
Good morning, Mr. Chairman and Commissioners. John Borkowski for staff. And with me I have Mike Dean, staff counsel, and also DeAndre Wilson, staff engineer. RM77 is an important milestone in grid modernization in Maryland because if successful here today, RM77 will accomplish the NARUC Board of Directors resolution in February 2020 that recommended state commissions act to adopt and implement IEEE 1547-2018 for smart inverters. And if successful, Maryland will also be one of the first states in the country to adopt IEEE 1547-2018. And RM77 addresses several topics, but the most important topic is having a Maryland smart inverter requirement and minimum statewide default inverter standard, otherwise known as an MSDS, which we hope to make effective April 1st, 2023. Next slide, please. Okay, so first, we're recommending codifying some new standards that are needed to implement smart inverters, and this was a consensus proposal, and we agree with the Solar Energy Industry Association comments that were filed that recommended our work group continue to assess compliance with future editions of these standards going forward. Next slide, please. We also have some regulation proposals related to the scope of interconnection jurisdiction. And as you recall from past rulemakings, we have tried to make a bright line regulation to clarify state versus FERC jurisdiction. And we did come across a situation that we explored further with electric distribution circuits crossing state lines where interconnection jurisdiction was cloudy. And we do have a number of electric distribution circuits in Maryland that cross state lines into Pennsylvania, West Virginia, Delaware, Virginia, and also the District of Columbia. So we felt like we needed to explore that a little bit further. Now, of course, the Federal Power Act has requirements for transmission of energy across state lines. And FERC found that transport of power using electric distribution, if the energy crosses a state line but is not intended to be consumed except for that utility's electric distribution customers, then it's under state jurisdiction. And so we're making that addition in our regulations. And we also have the FERC order number 2222, which also clarifies that when we get to DER aggregation, where aggregators can sell into wholesale markets, sell services into wholesale markets, even if that DER is connected electric distribution, but is selling as part of an aggregation into a wholesale market, it's still under state jurisdiction. So we codified that in this proposal. So those are the two changes with respect
Chief,
to
Do you mind if I interrupt you
Sure.
here and ask a question? I'm sorry. But you said something that piqued my attention, and that is you said if there's electricity that crosses state lines, and I may be paraphrasing, crosses state lines, but is only intended to be consumed by the utilities customers, that jurisdiction still resides with the state. Well, if it's crossing state line, my question becomes which state?
The state in which you're interconnected. This is jurisdiction for the interconnection, whether it's federal
Okay.
or
I
state. So if you're the situation we came up with was a situation, and it's a case that you're all very familiar with, the Perennial Solar. It was an 8 megawatt facility interconnected on electric distribution, but it was in the Pgm queue. And when we explored it, we found it was a gray area, in that we needed to put some clarity around. So
it's only for the purposes of interconnection, and
Right.
there's no interstate jurisdictional conflict created.
Right.
I wasn't sure what you said, and now
No.
you've clarified that. Thank you.
All right, thank you. Next slide. By the way, all this was a consensus proposal. Okay, the next regulation section is .06J, and this is specific to utility monitoring and control plans. Now, none of these plans have been submitted yet to the commission, but we do expect that utilities are going to want more granular communication requirements with smaller DERs as they put in their distribution energy resource management systems. And certainly, I think DERMS is going to be needed to some extent when we get to DER aggregation. So at some point in time, we're going to have communication between utilities and DERs at a much smaller size level than the requirement now in COMAR is 2 megawatts. And when they do submit these monitoring and control plans, we wanted to add some specifics, more specificity about what is required when they file these monitoring and control plans. So to that end, we're recommending some additional things be codified. We also wanted to establish some DER cybersecurity requirements, and that is also codified. Now, as far as stakeholder comments, I listed this as a near consensus proposal. We actually did not have any non-consensus in the work group, but there were comments filed on July 19th that indicated some non-consensus. And specifically, the Solar Energy Industry Association they have a speaker here today who could speak to this, and I believe Tesla is here also to speak to this. They oppose the requirement that DERs meet utility cybersecurity requirements because they're undefined, relatively undefined in the regulation. I would just say staff's position on this is that we need the utilities to protect the grid. At this point, DER penetration in Maryland is relatively low, roughly 4%, depending on energy or capacity. But it's growing, and the risk to the grid from DER cybersecurity will grow commensurate with the increase in penetration. And if we're going to have utilities protecting the grid and from a growing DER cybersecurity threat, then we need to have the ability for utilities to be able to implement cybersecurity to that end. I just want to remind the Commission that utilities in general, some of the larger utilities like First Energy and Exelon utilities are multi-state. And they're developing cybersecurity requirements to fit their corporate needs. They really can't be efficient or effective with sort of a balkanized approach to cybersecurity. So they are going to have specific cybersecurity requirements. And we also want utilities to be consistent with rules for cybersecurity, of course, that are going to come down with FERC Order 2222 implementation for DER aggregators in the future. So I do think there's a need for utilities to be specific with their cybersecurity requirements. I do disagree that they would be undefined, though. I think right now, for 2 megawatt units that are required by COMAR to have communication, in general, those cybersecurity requirements are specified in interconnection applications. And in the future, part of the specificity we added with monitoring control plans are for utilities to talk about their technical requirements, which presumably would include cybersecurity. So at that point, stakeholders would have an opportunity when utilities follow those monitoring control plans to be able to comment on the cybersecurity requirements. So that's staff's position. We recommend the wording stay as is. And I also want to emphasize CRI's comments. CRI, Harry Warren could not be here today, but he let me be his proxy, although I don't have a vote, so I don't know what that means. In any case, he wanted to emphasize, in Maryland, our goal with monitoring control and to some extent cyber security is to have low cost and secure communications. A lot of stakeholders want IEEE 1547-2018 compliant protocols to be implemented. However, utilities, at least in our informal discussions, indicate maybe some other requirements. So we've put in the report, and we expect when utilities file these monitoring control plans, that there's a full discussion of the benefits and costs at that time of IEEE 1547-2018 compliant protocols versus, a utility proprietary protocol that they may be recommending. So I don't know, that's my conclusion.
Chief,
there.
before you move on, I had a question in this area. I've been following IEEE 1547 development for some years, and you alluded to it. I don't know if you would agree with this characterization, but the original iteration in 2018 was very light on cybersecurity standards, and IEEE 1547.1 in 2020 didn't really get there either. And we've been promised for some years yet another 1 or 2 updates to 1547 to hone in and dig deeper on the cybersecurity issue, because I consider it a big vulnerability to our system. And what do we know about pending revisions to IEEE 1547? Where are they at in the pipeline, and what do we know what the discussion level is right now with regard to beefing up that IEEE standard, because it's not hitting the mark, in my opinion.
Yes, Commissioner O'Donnell, thank you for that question. Actually, we as a work group have been monitoring the development of a revised standard called IEEE 1547.3. And that is actually in balloting at this point. We know what's in that standard. There's videos out there on YouTube that you can watch. Get a 101 type tutorial on that standard. So we're hoping that standard is implemented in relatively short order. But at the same time, there are other standards out there that DERs can use. For instance, I would say standard versus framework. The National Renewable Energy Lab actually has a guide out there for DER cybersecurity that DERs can use when it comes to trying to manage their cybersecurity risks. So I do think that this is an area where there's a lot of focus. Unfortunately, there's not a lot that's been completed at this point, except, or at least published. But I'm hoping that with IEEE 1547.3 that we'll get there, and then we'll be able to have a lot of DERs adopted. And I think within the context of this proposed regulation, because it is an established cybersecurity standard or expected, excuse me, I think the wording is accepted industry standard, we would hope that, that the DRs would adopt that.
It's good to hear that, that it's continuing to be focused on. It's good to hear that that version of IEEE 1547 is emballoting. And I know this is an area of concern shared by commissioners and commissions
Yeah.
across the country through our service on the Neighborhood Electricity Committee and other forums. So it's an important point. If you had to hazard a guess, when might that balloting, and I know it's kind of like predicting when the Supreme Court may issue an opinion. Well,
Yeah, I actually, we have one of our IREC technical experts who's, I don't think he's here, who's on that work group and monitoring for us, but I don't know, you know, where we're actually at with the balloting process at this point.
all right, very good. Thank you, Chief.
Chief, just one other follow-up on that same area of cybersecurity. For purposes of the recommendation here, is it the intention that the DERs or the entities that have this requirement imposed on them, are they supposed to file something with the commission, or is it, how is the monitoring happen?
This would be part of the process when a utility is approving an interconnection request to verify not only if there are utility requirements, but also that you know, that the DR, I mean, they shouldn't allow the DR to interconnect if they have concerns that you know, they're not following proper standards.
Okay, so it'll occur during the interconnection process.
Hopefully.
Okay, all right, thank you.
Okay, next slide.
Just ask a question also on that. Just help me understand where there might be a circumstance when you would differentiate the, you know, when they, let's see, in accordance with accepted industry standards and utility cybersecurity requirements. Would those possibly just be the same thing?
Well, I view those to be separate to some extent. I view the standards to be frameworks that, you know, the DER has proper governance, they have proper risk management. They're addressing a lot of the areas of, that you would see, for instance, and you're probably familiar with the NIST standard because we've had utility cybersecurity. Well, there's compatible frameworks out there, and even to some extent IEEE 1547.3 has those frameworks. So I view that as different than a protocol, communications protocol with cybersecurity technical requirements. So I view them different. That's pretty much the way this wording is set up to be and meet utility cybersecurity requirements, but also, you know, design, install, and maintain and operate their facility to acceptable standards. So to me, there's a bifurcation. There's two different requirements.
Okay, well, thank you. I'll be interested to hear from the industry as to why they don't like that last part of the phrase, so thank you.
Okay.
And for the interested parties in the room, you will have an opportunity to approach the podium and respond after the chief finishes his presentation.
If I may follow up on that too, is that language consistent with what you had said, that there may be some different requirements for different utilities, so that language would kind of allow that?
Yes, yes. Yeah, no utility is going to approach it the same way, I think. Okay, next slide, we get to section 6K. I'm not going to dwell on this section. We had some minor changes just to update references with the new IEEE standards, and also require that DERs demonstrate that they can meet smart inverter requirements that are codified in other sections in COMAR. And we did identify that there's probably some streamlining that we can do in other sections of COMAR, but we'll take that up in phase 5. So next slide. So here's the probably the focus of what we're trying to implement for grid modernization. And, the big change is that effective April 1st, 2023, for all new interconnection requests, we want smart inverters to be installed, and this will help us facilitate grid modernization. And the only exclusion to that is where there's an existing spare that was purchased for a site, and if they sort of have to replace an inverter and they have a spare, we're not requiring that be a smart inverter because they've already purchased that spare. So that's the only exclusion that we have. I would say to implement smart inverters, though, you need to have inverter settings. Otherwise, you can't take advantage of all that advanced functionality. So that's really the core of what we're trying to do here when we're talking about both default utility required inverter setting profiles. We call that a DUURP. That is something customized to each utility, and it's their inverter settings for their utility that work hand in hand with their utility design, their voltage control philosophies, etc. And then you have the MSDS, which is a minimum statewide default standard. So to implement a smart inverter requirement in Maryland, you need both. You want your large utilities to take advantage of all that extra functionality, especially the voltage control capabilities. But you recognize that one size doesn't fit all, and you have smaller munis that don't have the engineering staff, for instance, to develop their own inverter setting profiles. So the MSDS is sort of a least common denominator inverter standard. It's something that can be plug and play, so to speak, that any small utility can use if they can't develop their own default inverter setting profiles. So there's two different tiers of implementation. We would certainly hope that all utilities take advantage of voltage control functionality, but if they don't, there's that fallback position. So we have to have both the MSDS, and for large utilities we want the DUURPs. I do recognize that some of the stakeholders are concerned about what the utilities are going to propose for their company-specific settings or their DUURPs. So we tried to find a way to have stakeholder intervention in this process, and what we arrived at is that we would like any DUURPs filed or changes to the MSDS filed 90 days in advance to give stakeholders an opportunity to intervene. We don't recommend that the Commission needs to specifically approve these unless there's a stakeholder request for an intervention, and then we're recommending that the Commission would consider that in the administrative docket at an admin hearing. So that's why we had the 90 days to allow for some transparency, and if there is a concern, a stakeholder could file, and then engineer would make a recommendation, and we'd go through just a regular buck sheet process with it. So that's pretty much what we're recommending be codified. This was a near consensus proposal. The whole smart inverter requirement was pretty much consensus. We did get some filings on July 19th. One that wanted to extend the ability for, we talked about that exclusion for spares. They wanted to extend that to warranty replacements. That was not discussed in the regular work group meetings, and I'm not recommending, staff is not recommending changing the wording, although, I think the wording is acceptable if the Commission decided to accept it. But I think it's a de minimis situation that would be very rare, so I'm not in favor of codifying, but again, I'm not opposed to the additional wording either.
Chief, is that the language that states this requirement does not apply to inverter replacements conducted under manufacturer warranty?
Yes.
And that's the proposal from the Interstate Renewable Energy Council.
Right.
Okay, if they're here in the audience today, we'll hear from them. Thank you.
Yes, they are not here. They let me know that they had a conflict, so I'm going to be the only one speaking about that, although SEIA is here and can speak to it. Okay.
Chief, before you go on, let me just make sure I understand these settings, whether MSDS or default utility required standards. Aren't they closely related to the cybersecurity requirements? Because I've been told for years that my cybersecurity concerns would be taken care of once the setting standards are established. Is that true or not true? Because what you don't want is someone hacking into the system and controlling voltages on a wide array of DERs because the standards aren't correct.
Yeah. Thanks for letting me clarify that. Yeah, IEEE 1547-2018, although they have some discussion about communication protocols, and there are basically 4 different types of protocols that are out there that are basically used for cybersecurity. In general, though, 1547-2018 is silent about cybersecurity, which is why we need, some of this other work that discussed earlier.
Oh, I know that. We established that earlier in my other line.
And
That's
there's
the
no
whole subject.
settings that I'm aware of in 1547.
But I'm trying to establish the relationship between these settings and their importance to cybersecurity. Because that's what I've been told for a long time, that cybersecurity would be enhanced and would be made more robust, if you will, through these setting standards once they were established in the 2018 IEEE standard or the 2020 IEEE standard or .2 or .3 or subsequent standards. These settings were a key metric and standard with regard to cybersecurity and not being able to control voltage on our grid.
Yeah, I am not aware, and I've been through the IEEE 1547-2018. I'm not aware of any cybersecurity related.
It's not there. I'm telling you, it's not there. I know it's not there.
Yeah.
I'm talking about the technical question of the relationship between these settings that you're proposing and cybersecurity. I think they're integrally, easy for me to say, interlocked.
I would say the reaction of the system is governed by these settings. So to the extent that if there's a problem, it could be cybersecurity somewhere, these settings will help utilities adapt and ride through disturbances that may be caused, by a cybersecurity incident associated with DER. But other than the actual performance of the DER, there's no direct relationship with the settings. There's an indirect from a performance.
I'm not worried about the performance of the DER. I'm worried about the
Right.
the cybersecurity of our electric distribution system
Yeah.
through these inverters and the standards that are set. We may want to look at that. I don't know that we need to do it today because this has been cooking and has been nagging at me for many years because I've been promised that this would be taken care of when these settings standards were established. But we maybe want to take a deeper look into that going forward.
Okay. All right. Well, thank you. Yeah, we are continuing to monitor developments in cybersecurity, both for DERs as well as just general utility cybersecurity.
Thank you.
Okay. Next slide. We have some relatively modest changes with regards to hosting capacity calculations that we're proposing. We do think, as a work group, that some of these hosting capacity issues need to be dealt with by the distribution system planning work group. And to that end, we'll work with them. So we did establish some minimum requirements, though, that utilities have to have their own procedure for calculating hosting capacity. And they also have to do validation checks of those hosting capacity calculations at least annually or more frequently if an area is experiencing a lot of DER growth. What we need the distribution system planning group to do is to standardize on methodologies and use cases related to hosting capacity. So we have some modest proposals, but we don't go as far as some other stakeholders like SEIA and IREC would like us to go. And so I think we have consensus on this proposal, but also there's a desire to do further work in this area, and I agree with that desire. Next slide. Okay, we have some relatively modest changes to our interconnection reporting. One concern expressed during work group meetings is if well, I have to step back for a minute. When utilities implement their inverter settings, the big thing we're looking to get from them is what are they going to do about voltage control? And in informal discussions with utilities, I feel like most of them, if not all of them, that are submitting these URPs, these specific inverter setting profiles, are going to be recommending volt var, which will be controlling voltage in normal ranges, and possibly volt watt when you get high voltage to protect the inverter and also help with the system. And volt watt is exactly what it says. If the volts go high, the watts go low. That's all you need to remember about volt watt. The problem with when the volts go high and the watts go low is that there's a DER curtailment, and DERs don't like to be curtailed. So in California, and we looked at what they were doing in California. I think we have some stakeholders from IREC and Sunrun, et cetera, that are very familiar with what's going on over. They have a lot of reporting requirements about complaints about the curtailments, but they also have some requirements about measuring the actual amount, the megawatt amounts of the curtailments. We took a halfway approach. We recommended complaint reporting so we can get an idea of the magnitude when utilities implement volt watt, if we're getting frequent curtailments, but we did not go as far as to recommend that the utilities quantify those amounts of curtailments to determine if they were meaningful megawatt impacts. So we can have some further discussion in phase 5. That is not a trivial task for utilities to quantify losses. In fact, it may not be possible if you don't have AMI, and even with AMI, it's not a trivial task. But at this point, we've implemented a modest approach. We're recommending that for now. We can have further discussion, and we can monitor what's going on in the industry. To my knowledge, and I may be wrong about this, California is the model out there. I'm not sure that other states are actually doing anything to the extent California is. So with that, the last slide, well actually it's the next to last slide, because I want to talk about next steps, but our recommendation is for the Commission to approve the proposed COMAR revisions that I just discussed and are in the document that you should have in front of you. We are also recommending the Commission approve the interim MSDS that we documented in our phase 3 final report, but we're recommending that that actually be the MSDS to be effective April 1st, 2023, meaning take the interim label off of it. We further recommend that the Commission note its decision on MSDS approval in a motion that's captured in the minutes from this rulemaking, because due to its technical nature, we're not recommending that the MSDS be codified. What we will do once it's approved is we will actually publish it on the Commission's website. I'm going to be also trying to figure out how to get this into industry databases, because to some extent any inverter to ship to Maryland would be shipped with these default settings for the MSDS, and then that's the base for which utility-specific profiles, might be adjusted, but the base for an inverter shipped to Maryland would be this MSDS. So the last slide is just our next steps. We actually are kicking off our Phase 5 a week from today. And I've discussed throughout my presentation a number of things we're going to be working on, but I do want to highlight just 2 or 3 of these. One is that we did express some concern in the past about the implementation date. And as you know, we moved that back from January 1st, 2022 to April 1st, 2023. And that is primarily because of a problem with the Underwriters Lab 1741 standard. And they had to go back and rework the standard. And it was reworked and published last September, the 3rd edition. And now we're comforted to see that actually there are inverters out there starting to be certified to that standard. So that gives us, some comfort that our target date is realistic for April 1st, 2023. We need to see more manufacturers certifying their inverters to this standard, but at least we know it's possible, and we'll continue to monitor it. If we have to make a change because there aren't enough smart inverter manufacturers out there certifying their inverters prior to April 1st, 2023, then we would just do what we did the last time and recommend a waiver. But we're feeling pretty comfortable about this target date at this point. One thing we did not mention, because we had no regulation proposals, but I think it's important to recognize that we're still working on a cause or pays alternative for cost allocation. We were, as a work group, working on a cost allocation method, which we call MCAM. And I do appreciate that OPC and their consultant strategy and Cadeo group came in with an alternative proposal, but the work group did not begin to evaluate that proposal until April. And because of the time urgency that we have in trying to get these regulations in place so we can implement our smart inverter requirement, we felt like it's going to take a couple more months to work through the MCAM proposal from OPC. So we're going to be doing that in Phase 5. And the other big thing that's on the horizon, and I know we're not going to have an implementation until around the 2026 time frame in Pgm of FERC Order 2222, but this is going to completely change a lot of things with regard to interconnection. There are a lot of issues, and we're going to be continuing to work on that in Phase 5 and beyond if we have to. But other than that, I'm available for any questions that you may have.
Oh, thank you, Chief, for all the work of you and your staff and your attorney on this very important, very technical in the weeds topics. Before we turn to Commissioner questioning, I would like to provide an opportunity for a number of the parties to respond, particularly if you are not supportive or have any objection to the proposal set forth by engineering staff. I understand that we don't have a number of the parties here today, although we know where their positions are, but we do have several parties that have informed the Executive Secretary that they wish to speak today. That may include the Solar Trade Association, as well as Tesla and others. So this is the opportunity and time for you to make an appearance and to petition the commissioners directly with respect to your proposal. So at this time, if you do wish to address the commission, I would ask that you approach either of the podiums. Good morning. If you could please state and spell your name for the record, along with your title and affiliation.
Sure. Good morning, Chairman Stanek, Commissioners. My name is Scott Elias, Scott, S-C-O-T-T, and then Elias, E-L-I-A-S. I am the Mid-Atlantic Director for the Solar Energy Industries Association, and I'm speaking on behalf of both SEIA and our Maryland affiliate, the Chesapeake Solar and Storage Association, otherwise known as CHESA. I want to start by commending John Burkowski for his tremendous job in facilitating the PC44 Interconnection Working Group that will result in Maryland being one of the first states to adopt the IEEE 1547-2018 standards and harness the true potential of smart inverters here in the state of Maryland. I will briefly touch upon the remarks that IREC made because I know they're not here because we agreed with them. And my understanding is that the reason for wanting to make sure that these revisions are not construed to mean that typical inverter warranty replacements are not allowed is that repairs for small inverters are often accomplished by replacing the entire unit with the same model shipped from the manufacturer rather than replacing the components. But I want to focus my core comments around our member concerns that it is premature for the Commission to assign authority to utilities to determine cybersecurity standards for customer-cited and customer-owned equipment. We think it is worth pointing out that while this was presented as a consensus recommendation, the report does note that a stakeholder throughout the process had suggested eliminating the good small generator facility cybersecurity practice recommendation entirely. And to be clear, SIA and CHESA don't oppose the idea that small generator facilities should adhere to accepted industry cybersecurity standards to the extent reasonable and practical. SIA has worked with the DOE for the past 2 years on a cybersecurity forum. We recently hired the DOE's lead on cybersecurity, and we're looking forward to engaging him in Phase 5 and further down the road. But what we simply oppose is the condition that customer-owned or customer-cited facilities must also meet undefined cybersecurity requirements. And I'd like to note that the report suggests that a guiding principle, that to accommodate future tech advancement, COMAR should be agnostic with respect to the types of communication links utilized between DER system providers, DER aggregators, individual DERs, and utilities. And we feel that this objective will be undermined by giving deference to the utility to define the DER customer and DER aggregator cyber systems. If a DER facility is contracted for utility services, then there's a much clearer need to align reasonable utility standards. But the rules as proposed would apply to DERs that are not participating in DER aggregations or utility programs, and they therefore may have no or extremely limited data exchange with utility systems. I'd also like to point out that a few months ago, NREL and UL announced that they are creating the first cybersecurity standard for DERs. And I think it makes much more sense to tie utility cybersecurity requirements to language referencing a nationally recognized consensus-based standard so that manufacturers and contractors have consistency in performance requirements and reliability and expectations for testing, communication settings, and protocols. Our fear is that the manufacturers of these equipment may need to make Maryland versions or sub-Maryland versions based on different EDCs, and such a scenario is unsustainable for long-term aggressive growth of DERs in Maryland. There is no doubt that DER industry as a whole needs to take cybersecurity seriously, but it is one thing to say that customer-owned and customer-cited facilities should adhere to best practices and guides and standards, and entirely another thing to say that they should also meet undefined utility cybersecurity requirements. So in conclusion, we respectfully request that you adopt our revised revision, which would strike the words "and meet utility cybersecurity requirements" from the COMAR revisions. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Elias. We did receive your 7 or 8 pages of written comments as well on this topic. On the screen before the audience, we do have your language that you wish to have struck here. Mr. Elias, have you had any conversations with respect to the utilities that would support your concern that the utilities may require that you have hardware that would need to be, in your words, Maryland specific, that would increase the cost for your developers and your customers?
So the conversation has been less with specifically Maryland utilities and more at the national level of whether or not those national and really international vendors would have to specify different requirements if Maryland went in a different direction than, let's say, California.
I understand that point, but do you have any reason to suspect that Maryland utilities in particular would be adopting cybersecurity requirements that are vastly different than neighboring states or other states in the country?
We don't, but we do think that the definition, if codified, would enable that.
I see your concern. I don't necessarily share it at this point. Not knowing what the particular utility cybersecurity requirements would be, I suspect our utilities in the state would work together to set some minimum baseline. I know your worry is potential cost, potential inconsistencies on a national level, not having one unified standard, and a fear that in Maryland, utility by utility will have different standards that would make doing business in the state difficult to say the least. But I don't see any evidence at this point that would necessarily support that position. I'll turn to my colleagues. Before you relinquish the podium, I'll turn to my colleagues to see if they have questions of you, and then we'll bring up. Are there others that wish to speak on this topic? Okay, if you could approach the next podium, and I'll yield to my colleagues if they have questions for you, Mr. Elias. Commissioner Bubar.
Thank you for that explanation. Just, is your proposal that those who would not have communication with utilities would not be subject to the standard, or no DERs?
So what this basically would adopt is a recommendation from PGM, which was, I think, intended for DER aggregations. What we're suggesting is that we shouldn't require DERs to meet unspecified utility cybersecurity requirements that may not be part of DER aggregations, which is the impetus for the language that was being proposed.
Okay. Thank you.
Commissioner O'Donnell.
Mr. Elias, would your language also affect, though, those utility developed standards for aggregators? In other words, would it say that the aggregators don't have to meet the utility developed standards?
That's not how I'd interpret it, because my understanding is that if PJM is codifying certain cybersecurity requirements in order to participate in PJM's DR aggregation, they would need to require with the standards that PJM
Yeah, but that's not the
defines.
utility, that's PJM.
Perhaps I'm not understanding the question, Commissioner.
Well, it just seems to me like you want to do away with any utility developed standards, even though you say they were developed, they were intended to be applied to aggregators. Your revision potentially takes it away from even aggregators.
With all due respect, I don't actually agree with that. What I think we're suggesting is not putting in sort of brief, vague language that enables broad authority for the utility to create undefined cybersecurity standards, not to prevent the ability for there to be cybersecurity standards for DER aggregation.
I'm not suggesting that. I didn't say that. What I'm suggesting is I understand your intention. I'm probing the unintended consequences of your proposal and what it may mean. And I think it may cause some harm. I mean, if you say don't tax me, tax the aggregators behind the tree, and then you propose a revision that exempts the aggregators behind the tree from being taxed as well, you didn't accomplish what you say you're trying to accomplish.
I think if the definition was specifying explicitly for DR aggregations, I think that's one thing. But as we heard before, the cybersecurity best practices and standards, which are, a guide that's being developed now, are different. That's why there's the and so I think we're talking about something that we don't know, the unknown that will be created and proposed, as opposed to something that we do know that has been proposed.
I get what you're trying to do. I'm probing what you're maybe accomplishing unintentionally. Thank you.
Commissioner Linton.
Yes, thank you, Mr. Chairman. So just one question for Mr. Elias. What's fueling your concern that the utility companies might adopt standards that are much different from the more generic ones that you're looking to have?
What's fueling our concern is members telling us that they're worried that it's going to be more expensive for them to be able to have the supply of these sort of new technologies within the state of Maryland. I think Tesla will be able to speak a little bit more in detail about the concern, but the general concern is that it would be Maryland-specific standards as opposed to international consensus-based standards.
So have you seen that utilities, perhaps somewhere else or even here in Maryland, have suggested that that's what they intend to do?
No, but I think this is such a new area that we're giving such broad authority to the utilities to do something that we haven't seen before.
Okay, so it's more the concern that they might, as opposed to the suggestion that they either have said they will or that somewhere else they've already done it.
Correct, and I think codifying it means it's more difficult to change it later.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you. We'll turn to the next speaker. If you could spell your name, title, and affiliation.
Yeah. Jordan Graham, Jordan Graham, and I am the Senior Energy Policy Advisor at Tesla. Chairman Stanek and Commissioners, I'd just like to thank you for the opportunity to speak here today. I'm here to discuss the proposed good small generator facility cybersecurity practice and to express significant concerns with a proposed change that would give utilities broad discretion to adopt their own cybersecurity requirements for small distributed generation and storage systems, or DERs. While Tesla did not directly submit comments on this matter, we contributed to the comments submitted by SIA and CHESA, which were representative of numerous stakeholders in the Maryland solar and storage industries. I'm here today to urge you not to provide Maryland utilities with the broad and undefined authority to create their own cybersecurity requirements on DERs, which is what your rule changes as proposed would allow. To put it simply, providing this discretion to utilities would be premature in the face of ongoing national dialogues on this issue. It could prove unduly burdensome to the solar and storage industries by creating a patchwork of utilities requirements at a time when efforts are being made for being made to increase deployment of these technologies, and it also may constitute a jurisdictional overreach of utilities seeking to apply standards to behind-the-meter DERs that do not participate in aggregations or utility programs and therefore have limited or no direct communications with utilities. Discussions are ongoing across numerous jurisdictions regarding data sharing requirements and cybersecurity standards that will facilitate implementation of FERC Order 2222 and allow broader participation of DER aggregations in wholesale markets. However, there is not yet consensus regarding under what circumstances it's appropriate for utilities to require utility-defined cybersecurity requirements that may differ from industry standards, and to whom within a DER aggregation those additional utility-specific requirements should potentially apply. For example, should the requirements only apply to projects participating in PJM or utility-sponsored demand response programs, or also to net metering customers? Would applying utility cybersecurity requirements only on an aggregator rather than individual DERs be a more cost-effective way to achieve the same security aims? As written, utilities would have broad discretion to create their own cybersecurity rules for all behind-the-meter projects. It is well accepted that developing industry cybersecurity standards requires a risk-based approach that balances the cost of security with the potential threat and determines the most cost-effective method of addressing vulnerabilities. That approach balances the needs and authorities of customers, manufacturers, aggregators, utilities, and regional transmission organizations. However, this approach requires a fuller risk and cost assessment, which has not yet been addressed in the Phase 4 report. It is reasonable to expect that some of the aforementioned questions should be answered with greater specificity before the Commission provides utilities with broad authority to create their own cybersecurity standards. Therefore, we recommend that the Commission amend the proposed COMAR language edition of 20.50.09.06J6 by removing the utility cybersecurity requiring language for now. However, it is reasonable for the Commission to maintain that DERs adhere to cybersecurity requirements in accordance with accepted industry standards, which would be sufficient, flexible, and would not hamper DER deployment. This issue has raised significant red flags for the industry, and we ask that at the very least you allow for further discussion on the matter during future working group stakeholder meetings. Thank you.
Thank you, Mr. Graham. Your comments were somewhat similar and aligned with Mr. Elias, so I don't have any additional questions. I turn to my colleagues, Commissioner O'Donnell.
Thank you, Mr. Chairman. So you seem to say something different than my ear heard, although you're generally aligned with the previous speaker. You seem to proffer that we modify this standard to apply to aggregators only and not behind-the-meter net energy metering DERs.
What I'm saying is that it's possible that there could be a benefit to having utility-specific requirements on DER aggregators, and potentially down the line that would be warranted. But when it comes to a risk-based approach for cybersecurity and determining what's the most cost-effective way to do that, that question has not really been answered or addressed as part of the working group.
I'm sorry, I thought I heard you say it would be more cost-effective to apply that to DER aggregators.
What I was saying was that, Commissioner, is that it's possible that that would be the case, and that it's also possible that it would be completely sufficient to have utility-specific cybersecurity requirements only on DER aggregators, but not just specifically on individual DERs. And that also, begs the question of whether it's appropriate to have utility-specific cybersecurity requirements on DERs that are not participating in any aggregations to utility programs. And so I think the gist of the comments is that these questions have not been answered, and therefore we find it to be premature to assign utilities this broad authority to have this utility-specific cybersecurity requirements on individual DERs. We think that this is ripe for further discussion, and if we take this requirement today, there's nothing preventing us from putting it back in place later on, discussing it further at the Phase 5 working group. And so because these discussions have not happened in that sort of robust manner, we think that it would be appropriate to remove the utility-specific cybersecurity requirement.
Yeah, I'm trying to discern a middle ground that adds maximum protection and yet doesn't affect the single practitioner, if you will, of DERs behind the meter. And I think that's what you want. I hear you saying, well, we got to talk about it more, but sometimes talking something to death is a killer. These regulations in this work group have been at it for a long, long time. And sometimes you just got to fish or cut bait. I'm trying to strike a middle ground that may protect the interests of SIA and Tesla and others while still affording maximum protections for the general grid operation and the utilities, to be honest with you.
One thing that I'm uncertain is that what exactly is the perceived risk? Is it that an individual DER will inject, power into the grid?
I'm not going to answer your question, so.
Yeah. No, I
It doesn't
understand
work
that.
that way, so.
I understand that. I guess part of the way that we're thinking about it too is that if the concerns have to do with voltage, the same cybersecurity requirements that exist here do not apply to load or appliances that might exist in a demand response aggregation. And so I think our part is that this just needs to be thought through a little bit more.
Thank you. I was just
I'm sorry.
questioning what you said originally in your comments, and you seem to be backing away from even that, so thank you.
Commissioner Richard.
Can I ask a question, Mr. Brokowski? This is a phased approach, and we're going into Phase 5. It sounds like there's an interest in discussing this further and maybe, fleshing out exactly what these industry standards might be. If we were to just adopt the language being proposed today by the industry representatives, there would be nothing that would preclude you from coming back with those industry standards at a future rulemaking. Is that correct?
That's correct. We have nothing now. I just want to remind everyone, we have nothing now. It sounds like we have consensus on at least the first part. We don't have consensus on the meeting utility cybersecurity requirements. But from a staff perspective, I still recommend that we include that.
Would accepted industry standards.
But we could step back and discuss it further in Phase 5 if the commission directed us to.
Yeah, I'm just trying to understand. I guess I asked that question before. Accepted industry standards sounds like would include a lot of what industry would want. And since we don't really have any specifics right now from industry, I am hearing the concern that Maryland might be starting to stray a little bit here if we are trying to come up with a policy, a regulation that's intended to advance our state policies and trying to encourage industry to come to our state to help us meet our goals. So I'm just trying to understand what the harm would be in maybe waiting to find out what these industry standards are before actually specifically empowering utilities to require that. Especially since we would, if even without that, we would be requiring accepted industry standards and not the.
Well, I think that, I want to bifurcate we're asked for two different things here. One is for the accepted industry standards, and there's no disagreement on that. That's how you manage cybersecurity risk for a DER. What we're talking about, utility-specific cybersecurity requirements, are technical requirements just to be able to communicate with a DER. It doesn't apply if you're not communicating directly with that DER. If you establish a communication link directly with a DER, then you need to meet the utility cybersecurity requirements. Similarly, and we do have a picture in the Phase 4 report of the PJM model where it talks about PJM for aggregation, how they're going to communicate with aggregators, how utilities would communicate with aggregators and dispatch agents and things of that nature. And that's all utility specific or PJM specific technical requirements. So, which to me is different than the standard, which is really governing a lot of your other things, making sure that you're controlling your risks, you're governing, you're training your people on cybersecurity, all those things. So it's two different issues, but we put it in one regulation. And if the commission felt that we should go back and work on the second part of that, we could do that. But at this point, I've given staff's position. I think I've been trying to carry a little bit of the argument for the utilities, and I would suggest maybe the utilities might have some perspective if any of them are here that can talk about cybersecurity. I'm not sure we have a specific rep.
Yeah, they're standing behind you.
I think he's waiting to go.
Okay.
Take your time.
I need some help.
Mr. Seegers.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers. Today I'm appearing on behalf of the Joint Exelon Utilities. I'm not going to add much to what Mr. Barkowski said during his presentation. I think he did a very good job of explaining the rationalization and the justification for the language. Just a couple of points that I would like to make. First of all, speaking on behalf of the Exelon Utilities, the cybersecurity measures that we have in place already comply with the NIST and industry guidelines. So that was one of the concerns of the industry advocates that we heard from today. So we already meet the general guidelines. And the second point I'd like to make is that utilities are different, and even within the Exelon utilities. BGE, for example, is all within one jurisdiction. And as Mr. Barkowski indicated, for Pepco and Delmarva Power, we operate in multiple jurisdictions. And if we have different cybersecurity requirements in our jurisdictions, it's not only going to make it make it harder to preserve our cybersecurity, it's also going to make it more costly for our customers. And also, IT is always evolving. And so we need to have the capability to make sure that we are able to protect our IT systems rather than waiting for general industry guidelines, which may lag behind when we need to implement certain protections. And the last point I'd like to make is that we've heard a lot, both in the written comments and in the verbal comments, that this could be a concern, and this is something that Commissioner Linton alluded to earlier. We have yet to hear that this actually is a concern, and we believe that we should wait to see if it does become a problem. If it does, then we're certainly willing to engage with the industry to address it. But we don't feel that the utilities that this should be taken away based on what is at now hypothetical, Your Honor.
Mr. Seegers, as a representative of Exelon, does Exelon currently, or does Exelon have plans to implement cybersecurity requirements on a state-by-state basis? I recognize that each utility is unique, as you just noted. But would your cybersecurity requirements be different state by state? Because that's the concern we heard from the SIA, CHESA, and Tesla representatives.
Unfortunately, I do not know the answer for certain, Your Honor. But given that the fact that we all are under the Exelon umbrella, I would suspect that there would be commonality between our cybersecurity across our utilities. As I mentioned before, we do have utilities in the PHI jurisdictions that do operate in different jurisdictions, so we would have to accommodate any jurisdiction-specific requirements. But as a general matter, Your Honor, I would anticipate that it would be the same.
Thank you. We'll hear from another utility counsel, Mr. Trout.
Thank you, Mr. Chairman. Good morning, Commissioners. Jeffrey Trout, Counsel to Potomac Edison. I strongly agree with what Mr. Seegers has said. I strongly agree with what Mr. Bukowski said earlier, and I strongly agree with the work group's result and recommendation. I do that for two reasons. The first is that there is not, in fact, a problem with keeping this language in, and the second reason is that there is indeed a problem with leaving it with removing it. To address the first point first, speaking for Potomac Edison, which is a First Energy company, our cybersecurity is managed on a total footprint basis, which is 6 states, all of which are PJM states. So if there is something in our communications protocols, and that's what Ms. Bukowski pointed out, we're simply asking the DER operators to communicate with us through communication protocols that work on our system. Those protocols are going to be across the entire First Energy footprint, and they're going to conform with PJM standards and requirements. So we're not talking about creating some sort of Maryland-specific, Potomac Edison, Maryland-specific requirement. We're talking about requiring the DER operators to meet PJM standards. And I think that's a very appropriate and reasonable request, given the burden that is placed on us, the utilities, to defend the cybersecurity integrity of our system and service to all of our customers. So that's why we believe there's no problem with leaving it in. The converse, why there's a problem with taking out the language that you've been asked to strike, is that you'll notice that the requirement to conform with industry standards that's placed on the DER operators is conditional. It's if reasonable and practical. And our concern is that if you don't also have a requirement to meet these PJM standard across the footprint communications protocols, someone's going to come in and argue that they can attach a device that doesn't, and that doesn't provide the necessary protection. So while we would be willing to have further discussions of this topic in Phase 5 or thereafter, depending on how long this work group goes on, we strongly urge you to put this protection in place now, as the work group recommended, as the engineering staff recommended, as the utilities are requesting, to protect at a PJM standard level the cybersecurity of our systems.
Commissioner Linton.
Thank you, Mr. Chairman. I actually have a question for either company counsel and perhaps even for Mr. Dean. So I see two different provisions here, and I'm curious as to which one you think supersedes the other in the event there's a difference, just based on how it's currently presented to us. If the standards are different, for example, if a utility offers a certain set of requirements that are slightly different or even significantly different from the industry standard, which one do we have to follow?
I read the language as being additive, and I base that on the word "and" in the last line there. So they need to meet industry standards to the extent reasonable and practical, and they need to meet our communication protocol standards.
And if the standards conflict with each other?
if if the standards conflict with each other, then we have a PJM-wide problem that needs to be resolved at the PJM level. But they're designed not to.
Okay, so both of you seem like, fine, trustworthy gentlemen. Tell me what happened to have the industry feel as though there's this concern that you're going to adopt something that's so much different from where the industry standards are, or even slightly different from where industry standards are.
I cannot say because I do not recall this topic getting a large amount of discussion in the work group meetings.
Mr. Stevens?
This is the same thing, Your Honor. I would just reiterate that if this language is kept in and the utilities are allowed to implement our practices, if a problem does arise, we are certainly willing to work with the industry in order to try and address it. We just don't think that that ability should be taken from us even before we have a problem.
So I can see the justification for that. I guess one of the things the industry has pointed out is that they're concerned about the ability to obtain additional equipment that could meet the standards that the companies might adopt. And so even if the companies are willing to have discussions and work out a problem, the industry could see there could be some residual impact from the decisions that the companies have made, whatever standards you've adopted, from the wider industry that probably isn't represented here now, but they'll begin the process of developing equipment and trying to move forward, and based on what you've produced as your standard. Is that an issue? Am I off base?
Respectfully, Commissioner, I do not believe that it is an issue.
Okay.
And that goes to the point that I made earlier, which is we're not talking about some squirrely Potomac Edison, Maryland requirement. We're talking about a requirement that would, in effect, be PJM-wide. So it's one thing to say you don't have to design, and I've been involved in this industry long enough to understand the concern of you have to build your widget just for one jurisdiction or one part of one jurisdiction. I understand that. But what we're saying is you need to build your widget so that it'll function in PJM. And I don't see that as a burden on the industry at all.
So you're suggesting that the utility cybersecurity requirements would be PGM cybersecurity requirements as opposed to industry-wide ones?
I am suggesting that any cybersecurity requirements that our companies would impose would need to be requirements, as a practical matter, would need to be requirements that fit the entire PJM footprint, because between our two companies, we represent, between our two parent companies, we represent a substantial portion of the PJM footprint. And we're not going to impose requirements that would not work in that footprint.
Okay, so one more question, Mr. Chairman, for Chief. Is it possible that the industry standards could be different from PJM standards?
Well, I think that it's probably clearer if you look at the diagram that's in the Phase 4 report, but PJM is only applying their standards on the first hop between them and either the utility or the DER aggregator. In general, PJM is only using two different types of communication. They're using either Jetstream SCADA, which is a proprietary product, or they're using their ICCP links, which they use generally with generating plants and utilities. They are leaving the communication between the utility and the DER and the DER aggregator up to utility-specific requirements. That's exactly what the wording is. It's the same wording we used here. So there could be different requirements that PJM uses for that first hop versus, what a utility would apply. But But I want to be clear, these are not going to be undefined. Utilities will need to come into the commission with their utility monitoring and control plans and talk about their technical requirements, and stakeholders will have an opportunity for intervention at this point. But the wording we use here is consistent with that wording that was used by the PGM DER subcommittee, but it's not undefined. It's not undefined because there will be an opportunity for stakeholder intervention. I think we're getting a little bit too worried about what utilities might do versus what they'll actually be allowed to do, because the commission will still have approval over those monitoring and control plans, and they'll be able. Then we can engage at that time in a much more robust discussion about the pros and cons and the benefits and costs and things of that nature. But I think we're just building into the regulations now that you have to meet utility requirements. You have to do that now. If a 2 megawatt unit interconnects, they need to communicate with the utility. That's already in COMAR. That's been in COMAR since the initial rules in 2007. They are utility-specific requirements. They have to meet now to communicate. And if they come in at a smaller level later, they're going to have to meet utility-specific requirements. But you will have an opportunity to see what those utility-specific requirements are in the monitoring and control plans.
Okay. Thank you, Chief. Thank you, Mr. Chairman.
Thank you. Commissioner Bubar.
Thank you. That was really helpful, John. So I think I have a follow-up question. I'm trying to understand what is the risk of not having this language in there, because we're worried about cybersecurity. So if we take this language out, but I also understand Commissioner Richards' point that we don't want to send signals to industry that make it too hard to come to Maryland. If we take this language out, then it seems as if we are leaving some risk on the table, particularly with aggregators, that there is not a requirement to meet the utilities communication or cybersecurity requirements. So I'm trying to understand if we're going to make a decision that kind of inherently leaves some risk on the table. I'd like to understand that.
Thank you, Commissioner Bubar. I may have a different perspective than some of the other stakeholders, but actually, if I were a utility and I were putting in a communication link with a DER and they did not meet my requirements to protect cybersecurity, I wouldn't let them interconnect. So there's no risk of not having the language, because to the extent that it's a gray area in the regulations. Utilities aren't going to, interface with a DER if they're not meeting their cybersecurity requirements today. This is just really putting
That's
it in
the
writing.
reality,
It's
the
just
reality.
putting it in writing because, again, we charge the utilities to protect the grid. And I don't feel like they would be doing anything just because it was a gray area in a regulation. I don't think they would be doing anything to adversely affect the grid just because we didn't address it in a regulation.
Thank you.
Can I follow up to that, Mr. Chairman? So failing to put it in the regulation takes away our ability to hold someone accountable to that standard. Is that true as well? I mean, I know the utilities won't intentionally interconnect somebody who doesn't meet their standards, but someone who doesn't meet their standards intentionally or otherwise, this gives us a mechanism for enforcement as well in COMAR, correct?
Well, I view it a little bit differently because we directly regulate the utilities. We don't directly regulate a DER, but the utility doesn't have to let it interconnect. So indirectly, we are providing regulation that affects that DERs because of the fact that we would have a requirement, and then utilities don't have to allow a DER to interconnect if they don't meet those requirements. But we have no way of enforcing it. The utilities need to enforce when they interconnect these DERs.
Understood. And I do appreciate the distinction, but at least we give some kind of force behind the utilities saying to somebody, you got to meet these standards, and they're PGM standards, and it's just the way it is. Thank you.
Mr. Chairman, could I just build on the points that Commissioner Bubar and Commissioner O'Donnell Matt just made? Mr. Bukowski is exactly right that push comes to shove, if somebody doesn't meet our minimum requirements, we're not going to interconnect them. But that party presumably isn't going to sit still if we refuse to interconnect them. They will complain to somebody, probably in the first instance to you all. And if we take these words out of this draft rule, the history, the legislative history on this requirement will be that the commission has said that the DER operator doesn't have to meet the utility standards in order to get permission to interconnect. And that puts us in an impossible position.
Thank you, Mr. Trout.
Let me just ask one question. Just Mr. Wilkowski, so you said that these utility cybersecurity requirements are defined. Is that what I heard you say? Or they're not defined, or something to that extent? Because what I'm hearing the industry, solar industry, storage industry saying is their concern right now is they don't have anything to look at. They don't know what these utility requirements are, yet they're trying to rapidly move forward with these projects.
Yeah.
So I just want to understand, is there something that the industry can see so they know what the rules are in Maryland?
Well, thank you for the question. The only real experience that we have with utility cybersecurity requirements are for existing DERs that have communication links with utilities, and those are primarily the large DERs. What we're talking about in the future is a much more granular level of communication, the smaller and smaller DERs. And that has not been defined, and that's what will be defined in the communication and control plans. So we haven't seen that, and the utilities haven't come in with their solutions yet for communication and control that would, presumably their technical requirements would address cybersecurity. So I think, at this point, while I would agree that we don't have a lot more detail that we can provide you at this point, it's not as if that opportunity isn't going to come when the utilities, present their monitoring and control plan. Then there will be transparency, and there will be an opportunity for stakeholder comment and possibly an intervention.
Yeah. Well, that's what I've heard the industry say today. They would like to take advantage now of this phase 5 to have just those discussions so that they can also be a part in the stakeholder process of helping to formulate those industry standards and at least have a chance to be a part of the discussion. Isn't that something that could happen in phase 5 and then come back and perhaps have this kind of language? I guess I don't still
I think
today of setting a very high bar, and that is accepted industry standards, and then allowing the industry to work in phase 5 to come back to us. And at that time, if it's deemed necessary, we could add further requirement on cybersecurity.
Well, I think that utilities may have different cybersecurity requirements, and that's to the point that I made earlier, and also we heard counsel for the utilities making. Utility cybersecurity requirements, because they operate multi-state footprints, they aren't necessarily going to be the same that you can adjudicate in a phase 5. We're not cybersecurity experts on the interconnection work group. I mean, we know enough to be able to write a rule or two, but when you get down to the technical details, that's going to be their cybersecurity teams and their holding companies, and they're pretty much going to be consistent, and they may not have a uniform requirement, in Maryland, but they will have to meet utility-specific requirements to be able to establish that communication link. PJM did not try when they did not try in the DERS subcommittee to establish an overall technical requirement for cybersecurity. They wanted to have their requirement for any communication links between them and a utility or an aggregator, or directly to a DER, because it could be that too. And then they left it up to utilities to have the utility-specific requirements between DERs and utility-specific requirements to aggregators. And that's all we're doing in this working group, is establishing in COMAR that language that was used in the PJM DERS subcommittee when they proposed their requirements.
All right, thank you, Mr. Chairman.
Thank you. Chief, we've spent a lot of time on 5 words today. As I stated earlier, I think the concerns of the Tesla and SIA CHESA representatives are speculative at this time. I am sympathetic to the position of engineering staff. These utility cybersecurity requirements, these 3 words, utility cybersecurity requirements, are those requirements vetted through the commission? Will they be commission approved or accepted before going into effect, or not?
Right now, there are requirements that are not vetted through the commission, and they are just documented in interconnection agreements, et cetera. But anything less than 2 megawatts that will be coming in the future when they want to implement their DERM systems will be vetted through the commission with the monitoring and control plans that they submit.
So that's yet another opportunity if some of the concerns of the advocates for removing this language materialize, there would be an opportunity for them to participate in a commission proceeding to raise any objections. Is that correct?
Yes, yes. And I would also add that if any stakeholder can prove that there's a detriment there, they can always file with the commission, for a waiver or, of this regulation. But I could tell you, if I were a utility, I would not want to interconnect with a utility that's not following my cybersecurity requirements. I mean, we're putting a lot of responsibility on utilities for protecting the grid, and I think that they have to have DERs meet their requirements.
Thank you. I would like to move on to some other topics, but I'll turn to my colleagues if they have any final items with respect to these 5 words.
Just a question, are we going to vote on these 5 words, or how are we going to handle this as far as just stating our final position on it?
We'll vote on the proposals at the end of this hearing today,
Okay.
including this
So
proposal.
we'll have a specific vote on this one.
To the extent, I'm going to propose a global vote after we hear from all the parties on other issues, and to the extent that any commissioner has concerns with these 5 items, they could vote separately or.
Well, I will make a motion to strike those words at the right time.
Okay.
Thank you.
Thank you.
Chairman.
Thank you. All right. Well, we'll move on to other items if parties have concerns with other items on this largely consensus proposal. Seeing none, Mr. Burkowski, do you have anything further?
No, thank you, Chairman. Mr. Chairman, I have concluded my remarks.
We have a couple commissioner questions. Commissioner O'Donnell?
Just a comment. So whenever we started PC 44 and pulled it together many years ago, we started, I think, how many work groups? 5 or 6, 5 work groups, and we've now added the 6 with distribution system planning. And each commissioner at the time of those 5 working groups kind of areas was assigned to kind of, kick off the work group effort and to kind of give some initial cheerleading and let's go modernize our grid kind of fashion. And I had this one, interconnection, and I wanted to take this opportunity, Mr. Chairman, to say that I'm very pleased with what this work group has been able to accomplish over several sets, and we have some more to come. We're not done yet, but they've done a very good job in what is not necessarily a sexy area of COMAR in interconnections, but a vitally important piece of transitioning to accommodating state policies and DERs and interconnections, and while maintaining the safety of our grid and the safety and integrity of our distribution and transmission systems. So I want to thank the work group, all of the stakeholders, all of the parties who have participated over many years in this area, because to me, it's not something you're probably going to read a lot about unless it's a trade press or something, but not in a general milieu of reportage. But I think it's very, very important. And Mr. Chief, and to all the staff and the engineering staff and all the utilities and all the stakeholders and others who participated, thank you, because this is important stuff.
Commissioner Bubar.
Thank you. I just want to say this was very intimidating to me when I first started getting into this because of all the acronyms and the technical issues. I mean, in a previous life, MSDS meant Material Safety Data Sheets, so I had to learn that no, it means something else. So I'd like to thank the engineering staff and for just your clarity and helping me understand these issues. But this dialogue has also been very helpful to understand the different perspectives as we try to find the right balance. So thank you.
At this time, I'm going to propose two motions. The first one will be with respect to the proposed regulations, and the second one will be with respect to staff's request for approval on the MSDS. So with respect to the proposed regulations, which I'm going to include staff's proposal here, and to the extent commissioners disagree, this will be the time for them to note any disagreement. So I would move that the Commission publish the draft regulations as discussed today regarding revisions and additional regulations to Title 20, Subtitle 50, as proposed by staff originally on June 23, 2022, as modified on July 19, 2022, in the Maryland Register for notice and public comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
Aye.
and Commissioner Richard.
So are we moving to the whole
The whole,
amendment right now?
S-
Are we entertaining amendments, or what?
we are taking a vote on staff's proposal, which includes these 5 words.
Okay, so if I would want to propose that we strike the words that were requested by industry, is this the appropriate time to do that?
No, this would be the time to either vote yes or no on the package, or yes on the package without these 5 words, which I believe is your position.
Yeah, yes. Okay. So I vote yes on the package without these 5 words.
Thank you.
Thank you.
I vote yes on the staff proposal, noting Commissioner Richard's partial objection / dissent on these 5 words. The motion is approved. The second motion, I move that we accept the PC 44 Interconnection Workgroup's Maryland Minimum Statewide Default Standards as described in Table 4 of the Phase 3 report. That vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Before we conclude today's hearing, would anybody else like to be heard? Seeing none, I would just like to echo what Commissioner O'Donnell has said. We've moved from Phase 4 to now Phase 5 of this proceeding. We do appreciate how much consensus we have reached and all the time and effort spent by the parties to date.
And
Commissioner
I would also
Richard.
like to, I think it is great to see all the consensus that we have reached to date. But I do hope that as the work group meets, I mean, we are going to be depending a lot on these industries to, as use the word speculate. I mean, they have to speculate, a lot. They have to look at where the business risks are. So I think it is very important that we listen carefully to the developers of solar and of storage to make sure that we are in fact creating a welcoming environment here in Maryland so that we can achieve our state policies, which are very ambitious. So with that, I thank you again for this product today.
This hearing is now adjourned.